database and enables itself to go and search it at will in a large pooled database, should that be seen as a secondary event that suggests the requirement for some gatekeeper before they have full access?
Well,
my time's expired, so I can't continue the conversation any further. But thank you, Chairman, for the hearing.
Senator Klobuchar.
Thank you very much, Mr. Chairman, and thank you to Senator Franken for his good work in this area and for allowing me to go before him. That was nice. Thank you for all you have done. Like Senator Whitehouse, I've had experience with this before. For 8 years, I managed a prosecutor's office with about 400 people and have been personally in the room for some of these wiretaps. They weren't federal wiretaps, they were local ones. But as many of you noted in your testimony, it's critical that our laws reflect this balance between national security interests and privacy, civil liberties. That's one of the reasons I co-sponsored and voted for the bipartisan USA Freedom Act. What I wanted to ask you about was that bill itself as we look at the reauthorization ahead and what we should be doing when we consider any changes to the law. As Section 702 is currently constituted, do you believe that it strikes the appropriate balance between the protection of national security and civil liberties, and what changes would you like to see? And we can go down the line here. Mr. Weinstein, sorry.
Thank you, Senator. Yes, I do think it strikes the right balance, and I believe it does that by providing for ample oversight, which is meaningful oversight by all three branches. And then also, I think you see that balance being played out in terms of the internal procedures that are implemented by the intelligence community, which are reviewed by the FISA court and then also by the intelligence judiciary committees, and have resulted in the finding by the Privacy and Civil Liberties Oversight Board with a finding that there have been no instance of intentional misuse of authority, which I think is very meaningful.
Right. Thank you. Mr. Olson.
So I also, Senator, believe it should be reauthorized. I was, along with Mr. Weinstein, part of the effort in the executive branch in 2008 behind the passage of the law, and can attest to the way in which it was calibrated at the time to make compromises on both sides, I think, to achieve an appropriate balance. But it's also not been static. It's the implementation of the law has been dynamic and has changed over the years, and in particular, what I think really is a landmark report by the Privacy and Civil Liberties Oversight Board, which did an intensive and thorough investigation, found that the law was not only valuable but also constitutional and legal, made recommendations which then the executive branch has implemented.
You think one of the concerns that Ms. Goetting raised in her testimony was that there's too much data to analyze, and that can be, do you think there's merit to that?
I did read that part, and I with respect, don't think there's merit in that. I served at the National Counterterrorism Center. I can tell you that more data of this type, 702 data, is better than less. The government has the ability to, with that data, search it, and we talked about that, search it, process it, and has a better chance of finding those needles that we're looking for when we're trying to stop a terrorist attack. So that can be a concern in other contexts. I understand the more data might just obfuscate the needle. In the 702 context, I don't think that's a persuasive argument.
Thank you. Ms. Goetting.
So I believe that Section 702 goes much further than it needs to go in order to accomplish the aims that I think we all want to see accomplished. And I would point out that some of the cases, in fact, all of the cases that have been made public relating to Section 702 successes, are cases in which the surveillance, the Section 702 surveillance, was of a known or suspected terrorist or someone known or suspected to have ties to terrorism. So while these are certainly evidence of Section 702 working, they do not support the idea that Section 702 needs to be as...
I didn't want to. I just want to.
I'm sorry. I realize that you're short of. So the Brennan Center's position is that the only way to secure the constitutional validity of Section 702 is to have an individual order when the government collects communications between a foreign target and an American. But there are many, many other steps that could be taken to improve Section 702. That includes closing the backdoor search loophole. It includes narrowing the definition of foreign intelligence, narrowing the pool of people who can be targeted, so it's not just any foreigner overseas, and ensuring that notice is given any time that Section 702 evidence is used in court, or evidence derived from Section 702 is used in legal proceedings.
Mm-hmm. Do you want to add anything, Ms. Medine? Ms. Brand?
I recommend three legislative changes. One is require the government to estimate the number of Americans' communications that are intercepted under 702. Second is tighten up the upstream about collection process. And third is to require court approval for queries of Americans' information under 702. And following up on Senator Whitehouse's point, is there's been no warrant issued for these collections. And when the attention shifts to Americans' communications that are collected over a 5-year period with any of 90-plus thousand other people outside the United States, I think it becomes a moment when the Fourth Amendment would require court approval.
Okay. Thank you. Last but not least, Ms. Brand.
Thank you, Senator Klobuchar. I would urge Congress to reauthorize Section 702, and I do not think any changes to the statute are necessary. I would note that the PCLOB, in our very in-depth review of the program and our lengthy report, did not recommend any legislative changes. We did recommend a number of changes to the way the program operates that could be implemented by the administration or the FISA court, and almost all of them have been already implemented. The government is continuing to work on some others, so I think those are the appropriate way to handle it.
Thank you to all of you. Thanks.
Senator Blumenthal.
Thank you, Mr. Chairman. Welcome to this very important and helpful panel. This is a very complex topic, and you've given some very insightful and intelligent responses to difficult questions. Having spent a good part of my career before this job in various courtrooms, I am a strong believer in the importance of the adversarial process in ensuring that a court has the best possible information to make decisions. And as a result, I proposed some years ago that a special advocate be established to argue before the FISA court, as you know, in cases presenting particularly novel legal issues. And I'm pleased that a version of this proposal was incorporated in the USA Freedom Act. I know that enabling the FISA court to hear independent views was among the PCLOB's recommendations, for which I thank you, and that a panel of outside lawyers has been established accordingly. And then on several occasions, the court has actually appointed one of them to serve as amicus. So let me begin by asking Mr. Medine, but this is really a question for the entire panel. Could you discuss why the PCLOB initially recommended this change and how you've assessed the process of implementation, and then also whether a technical expert will be shortly appointed to fulfill the role that was envisioned by the statute?
Senator Blumenthal, the origin of the recommendation was the PCLOB's first public workshop. We invited a former judge from the FISA court to testify about his experiences. And he said how frustrating it was as a judge to only hear one side. He said in his normal civil or criminal docket, he hears one side make an argument, sounds pretty persuasive, then the other side makes an argument, that sounds pretty persuasive too, and the judge's role is to reconcile those competing views. But when he was on the FISC, he only heard one side. And that led the board to ultimately recommend that there be another side, particularly in cases having novel legal or technological considerations like programmatic approvals of 215 or 702. I think we've just begun to see how that program is operating, so I think it's too early to test, but I think it's encouraging that a advocate, amicus, was appointed and that the amicus was able to make arguments. And we also support having technical advice as well, because a lot of these programs have important technological implications. Our board has just brought on our first technology scholar to advise us on these issues, and I think blending the other side of law and technology is important to make the court process work better.
May I jump in, as a member of the PCLOB as well, who signed on to the recommendation for a special advocate in the FISA court? What I saw prior to the board's 215 report was a lot of public mistrust and misunderstanding of the FISA court process and a mistrust of the FISA court because it was viewed as a rubber stamp. Now, of course, folks that have served in the Justice Department, like Mr. Weinstein and Mr. Olson, who have been in the FISA court process, know that that's not an accurate description of the FISA court, but the public certainly viewed it that way. And so I think it's important to have some for the public to have some visibility into how the court works and for the public to have more confidence about how the court works. And so I think that the public advocate serves that purpose. I think the two recent occasions in which the FISA court has appointed an amicus, I think they've been useful to the court, and I think they've helped to illuminate the process for the public as well.
But the help to the court has not just been in appearance. It is enhancing the perception of actual scrutiny and the value that you described, Mr. McGee, to judges who hear one side and then the other side is not just an entertainment value. It's actually, it elucidates questions. It permits the contrast and conflict of ideas, and out of that contention, sometimes heated, emerges a better conclusion for the court.
I agree with that, but I do think there was a real misunderstanding in the public because there was a sense that the court didn't push back, that the court just simply accepted what the government said at face value, and that was not an accurate perception. So I agree, it will refine the court's thinking, it will challenge the court's thinking, and that's a very important benefit. It will also then have the benefit of assuring the public that the process has integrity.
Did you have a response, Ms. Coteen?
Well, Senator Blumenthal, I wanted first to just thank you for your leadership in ensuring that that very important provision was part of the USA Freedom Act. I think it was very important. I do not see the FISA court as a rubber stamp at all, but I do think that it has in the past seen its job, and I've heard this from former National Security Division attorneys, as getting to yes, and that's not the role of the judiciary. I think part of that was that when there wasn't another party there, the court wasn't in the role of being a neutral adjudicator between two sides, and therefore if the court said no to the government, the court effectively became the other side. I think that was a very uncomfortable role for the court, and I think it made the court more inclined to try to move toward yes. So I am hopeful that having an amicus there will ultimately help the court to take more of a stance as a neutral arbiter. I think that will take time. I think it will be a cultural shift, but I think so far it's a very good thing that this is in place.
My time has expired. This is a very important topic. I know it's an evolving question. I just want to say for most of my career, I was a government lawyer, and so I wanted the court to get to yes. But at the same time, I welcomed actually a strong adversarial process because it made the case better. It reduced the likelihood of a successful appeal. And we're dealing in a different context here where appeals are unlikely, but still the result is better. And as all of you know, a judge's worst nightmare is a defendant representing himself. For all the reasons that you well know, and since my time has expired, I'm not going to go into them, but I welcome and thank you for your very, very important work in this area. Every one of you, thank you very much.
Thank you, Chairman Grassley, and I'd like to thank Ranking Member Franken of the subcommittee and all the witnesses for your very hard work in a very difficult area that really is about balancing our national values, our security, and our enduring concerns about privacy. This is a debate that goes back to the founding of our republic and is, as you could tell from attendance at the hearing today, still vibrant today. Let me try to cover some ground that hasn't been covered thoroughly because there's an awful lot of questions that have gone back and forth between this very able panel and members. My understanding is the government doesn't obtain a warrant before querying the Section 702 database for information about Americans, despite an expressed understanding from some members who were present when Section 702 was adopted, that it wasn't intended to allow this type of warrantless search of Americans' communications. Can any of you proffer an estimate of how many communications with U.S. persons have been collected under 702? I understand it is difficult, but if anyone can give us an estimate, I would welcome that. And can you answer the question, do you think we should require queries to be tracked in order to obtain information about how often the Section 702 database is used to search for information about U.S. persons? I see ready volunteers.
Senator, there's a challenge in quantifying how many Americans' communications are collected. Our board recommended some metrics, and I know that recently, Director Clapper has indicated he will be trying to come up with some estimates. I think it would be useful to require by legislation that the Director of National Intelligence report annually to the Congress on the number of Americans' communications that are incidentally collected and the methodology used to do that, because that's an important part in this reauthorization.